Yes, Your Honor. This is the application brought by the amended summons dated the 20th of May 2024. In terms of the order of priorities, or the priorities of the orders which I seek, noting that the orders in the amended summon are somewhat out of order, I would seek that the originating motion and the plaintiff's summons be summarily dismissed. If I'm not successful in full, then those relevant parts should be struck out. And then, again, just working through a tree or a hierarchy of orders, if, again, I'm not successful, then my alternative submission would be that this proceeding certainly be stayed until some appropriate form of originating motion is circulated and approved in draft by the court.
Yes.
Within what I would say would be an appropriate period of time. So, in essence, it's sunset orders. But, primarily, the primary argument is that the proceeding be summarily dismissed. And just to confirm, as I indicated yesterday, that is based on matters of form as opposed to relying on those submissions, which I argue that there is no evidence. If it would assist Your Honor by way of a very brief chronology given the length and history of this matter. The plaintiffs filed the originating motion back on the 29th of September 2022, and they were sealed on that date. The defendant's original summons was then filed on the 2nd of November 2022. The plaintiffs then filed the further amended summons the next day on the 3rd of November 2022, and then the defendant's proposed amended summons was circulated on the 18th of November 2022 along with an outline of submissions in support of the proposed amended summons, and then in its current form it was filed and sealed on the 20th of May 2024. The primary point in relation to, in essence, the entirety of the originating motion and the plaintiff's further amended summons is the issue in terms of standing. That is, I say that the individual plaintiffs, the persons, cannot claim standing to seek relief on the company's behalf, and then that goes into folds neatly into the next point. That is, the company's participation in this proceeding.
Just on the company, the originating motion was filed on the 29th of September 2022. I believe.
Yes.
Just on the company, the originating motion was filed, and that's at a time when Mr. Ansell had a practicing certificate.
Yes, I accept that.
So are you saying that?
Sorry, I just joined the link. My link was disconnected, I missed it, so.
All right, thank you, Ms. Zhu.
Yes, Your Honor. The final page of the originating motion indicates that the fourth plaintiff, People's Shoppers, represented at that time by Peter Ansell. The originating motion itself as well as the further amended summons in the tram tracks on the first indicate that it was prepared by Mr. Cucchiara.
Is it the case that even on your argument the originating motion was validly filed in the sense that it was a step taken by a company through a solicitor?
Yes, Your Honor. The final page of the originating motion indicates that the fourth plaintiff, People's Shoppers, represented at that time by Peter Ansell. The originating motion itself as well as the further amended summons in the tram tracks on the first indicate that it was prepared by Mr. Cucchiara.
So if you wouldn't mind expanding for me the argument about this question of standing in the sense of what is the law as to who has the standing in a judicial review proceeding.
The issue in relation to that, I think as we've cited at some point, is best summarized in my submission from Ainsworth in the Criminal Justice Commission, and this is the case in relation to a report that was produced and was to be conveyed on behalf of that commission to various persons, and applications were sought for judicial review primarily to issues in relation to procedural fairness about that report. I apologize, Your Honor. Does Your Honor?
Yes, I've got it open.
The majority judgment in that case really looked at the question of, well, who and what was being affected, and what were the legal rights or interests. So, for example, at p. 577 of that decision, and that's in the middle paragraph on that page which commences with the sentence, so far as the decision in Testoro Brothers is based on review, and continues into the next sentence which I'll read. And as the law has progressed since that case, the only question which now arises is whether the report adversely affected the legal right or interest, including an interest falling in the category of legitimate expectation such that the indistinct was required to proceed in the manner that was fair to the appellants. The court then continues, and, obviously, this is very much within a framework of procedural fairness, but continues into p. 580, and there's, at the final paragraph of that case, the joint judgment on the drug judgments commences with the sentence of, the function of certiorari is to quash the legal effect or the legal consequences of the decision order under review, and then it goes on to say in the two sentences below, it is different where a report or recommendation operates as a precondition or as a bar to a cause of action, whereas a step in a process capable of altering rights, interests or liabilities. The point that is to made from here, and, again, I apologize, Your Honor, to move quickly, but over the page from the top of p. 582, and this is where the court considers issues about declaratory relief. This is a connection between, if Your Honor has p. 582 open?
Yes.
From about the second sentence after the footnote number 38 the sentence reads, the person seeking relief must have a real interest, and relief will not be granted if the question is purely hypothetical. If relief is claimed in relation to the circumstances that have not occurred or might never happen, or if the court's declaration will produce no foreseeable consequences for the parties. The issue here is, in my submission, is that the
But aren't you confusing 2 points in that Ainsworth is saying when will the court intervene to make orders because it might not matter?
Yes.
Yes, but what I'm really asking about is why is it that, and what is the law on which you rely to say that people shop, assuming that the court will intervene for the moment? What are the authorities you rely on to say it is only people shop that can prosecute the claim and not Mr. Cucchiara, Mr. Ansell, and Ms. Zhu?
That is the point that I would say is because here neither of those three individual plaintiffs have a real interest in terms of what is being sought. What is being sought is in relation to various actions, and I'll come to Mr. Ansell later, but various actions or decisions taken by the board in relation to the law practice Erudite Legal, which was a trading name for the company People Shop Pty Limited. In that sense it is the company who has the real interest in terms of seeking the relief. Not the individuals who have variously been employed or might be a shareholder or have some sort of office in relation to the company, like I said.
Is there any authorities sort of more directly on point that say, look, this is for the company, not the shareholder, not the director, not the employer?
I don't have them at hand, Your Honor. In my view the matter is, in some essence, very much simply approached via that issue of standing. The person who has standing or the thing that has standing really here is the company, because it is the decisions that were made that affect the company. The company, of course, in some senses first principles, the company has legal personhood, and, certainly, persons may take steps, like a solicitor on behalf of the company, and obviously, secretaries and directors have certain functions and powers under the Corporations Act, but the legal person whose rights or interests or liabilities were affected by the board's decisions with the company. Not these individuals. Certainly not a shareholder like Mr. Cucchiara. Certainly not at the time when those decisions were made. Mr. Ansell, who was not the principal solicitor. Mr. McGregor in the beginning of the audit was, and that's, for example, that's the nail of the decision to appoint Mr. Nayland, and certainly not Ms. Zhu, who had various positions within the company. The ASIC extracts do make that clear. Now she is the current secretary.
Where is the ASIC extract?
Well, I was hoping not to take Your Honor to evidence, but that has been in one of the NST affidavits in this proceeding, outlined.
So in terms of the evidence, you rely on?
Really, issues of form.
Form.
Yes, so it wasn't seeking to.
No, I understand.
Yes.
No, the merits.
Not the merits.
There's no exploration of the merits of the arguments, as such.
Not the merits.
Yes, no, that's all right. I know it's in there. So beyond the standing point, and I understand your argument that I understand your argument that the appointments of Messrs. Nayland, Rapke and Cooper are all in the past now, but is there not a public interest in declaring that that appointment was made for an improper purpose if that is what the court is ultimately persuaded was the case?
Well, putting aside those 2 points, Your Honor, putting aside the irregularity of the company's participation and the contradictions between the further amended summons and the originating notion, the other issues on the face of the further amended summons are, firstly, of course, that the chapeau to paragraphs 1, 2 and 3 is, in and of itself, in my words, bad.
Yes.
That is, bad in the sense of it particularizes somewhat contradictory matters between the Uniform Law and the Corporations Act, and it relies upon other matters by the grounds within the originating motion itself. So in that sense, it would be somewhat artificial to dismiss or, on one hand, strike out the, in my words, conspiracies put by the plaintiffs against the board and against various defendants, while at the same time, preserving, somewhat artificially, these 3 paragraphs. Because these 3 paragraphs, as I understand the allegations that are being put, are essentially wholly based on those conspiracies, as opposed to the legality of the appointments themselves.
But if an originating motion had been drawn that was a judicial review application challenging the decision to appoint Mr. Nayland and the decision to appoint Mr. Rapke and the decision to appoint Mr. Gorton, and it was brought by the company and the ground relied on was that the appointment was for an improper purpose, wouldn't it have just proceeded through without anyone taking any exception?
Yes.
And the affidavit evidence would have either made good that assertion or not.
Yes, I accept that, Your Honor. The problem is that we then again buttress against that issue, in my submission, that there is no affidavit presently that makes good those purposes.
Yes, but that's a different point.
It is, I accept that, but we've never said that the arguments that are put at the height of 1, 2 and 3 are not matters that could be justiciable. But they are certainly not, in present form, when they rely on everything else that has gone before the originating motion.
Yes, and if you were to persuade me that everything else should be struck out, we haven't got to that argument yet. That wouldn't still mean that I would have to strike out paragraph 1, for example, of that amended summons.
Yes.
Does it?
It does in the sense where it would be artificial, because paragraphs 1 and 2 and 3 rely on, firstly, that chapeau to the further amended summons, which in and of itself relies on those matters that are set out in the originating motion. It would bring it to a fairly artificial exercise, in the sense that it would also, as I understand the claims that are being put, restrict the plaintiffs from articulating the various conspiracies that have been alleged.
No, but couldn't they still lead such evidence as they want to lead to prove facts from which the inference should be drawn that there was an improper purpose behind those steps by the board? Now, the board might go into evidence, or the board would either call people to say, I made the decision and this is why, and expose them to challenge, or it could choose not to and it could choose to argue that the evidence put doesn't justify the inference.
Yes.
There could have to be an exploration of the evidence and what inferences can be made, but that would not be an abusive process. Would it, in the legal sense?
No, I have to accept that it wouldn't. That certainly has been, while we haven't necessarily opposed the setting down of those 3 orders, noting down the original approach taken by the judicial registrar and certainly, in some sense, in expectation of that occurring, the second affidavit of Mr. and St. Leave was sought and that was filed in this proceeding.
Yes, I have been talking about 1, 2 and 3. Really, I'm just talking about paragraph 1, at this point.
Then I can confine myself as such.
Yes.
But in isolation I certainly wouldn't disagree with Your Honour about the utility and the justiciability of paragraph 1. The concern that I have is, and certainly when it's reflected on the rest of the originating motion and the rest of the further amended summons, is that what is being alleged here is based upon a variety of claims that are abuse of process or scandalous or simply irregular. In my submission, it would be very hard to be able to in practice in the running of the hearing separate out and deal with ground 1 without it essentially becoming a rolling judicial review of all of the other claims and grounds that are being put against the defendants.
Can you just expand on that point?
Well, in terms of the rolling nature of the judicial review, it is 2 things. If Your Honour, for example, summarily dismisses or strikes out all of the other aspects of the originating motion or the further amended summons, and Your Honour, I've just heard something on the audio. I'm not sure whether someone else has just joined or if Your Honour would like me to continue.
No one's dropped out.
I can continue then.
My understanding is Ms. Zhu is on the line. Mr. Cucchiara and Ms. Zhu are in the same house.
Yes, thank you, Your Honour. Apologies, Your Honour. I just heard something.
Yes.
So in relation to the rolling nature.
Sorry, Mr. Cucchiara's not with me right now. But I didn't make sound. Sorry.
That's all right, Ms. Zhu. When you say H is not with you, you mean H is not in the room with you.
Yes. He has disconnected, and then I came through a different room to join to listen to Mr. McAuliffe.
Okay, thanks.
Yes.
So the other issue then, Your Honour, if I could continue, is if that occurs, if everything else is dismissed or struck out and we're left with, say, for example, paragraph 1, then there is, in my submission, coming to that second issue within the Ainsworth, is there is an issue in terms of whether there is any utility in even dealing with paragraph 1 given that there would be no foreseeable consequence for the company, because it's not registered as an incorporated legal practice, it has certainly, there's no associated principal solicitors, and it is not operating or providing any legal services.
Even accepting if that's all the case, would there not still be a public interest in granting relief if there were evidence that established I know that your client disagrees?
Yes. No. I accept the theoretical, yes.
Yes, that the board has improperly appointed people to take over a legal practice. I mean, I have to work on the assumption in this application that it's not a strikeout on the evidence, so what you're really saying is that even if the court were, as a thought experiment, if the court were satisfied that the appointments were effected for an improper purpose, the argument that it would decline to grant relief is so strong that the case should be dismissed at this point.
That's so, yes. Because even if there was some sort of public interest, the issue that arises is that there is simply no utility given the fact that the company is not permitted and is not trading as, or working as a law practice.
Yes, but the answer to that is, well, the reason it's not trading as a practice and it's not trading is because of these appointments. That will be the answer put back at you. What's your response to that? I mean, it can't be a world where the board takes over a practice, ends the practice, effectively, and then says to that practice, because you're not in practice anymore, you've got.
There's no utility.
There's no utility in challenging what we've done.
No, I accept that, Your Honour. The difficulty here, well, the reason why I would say it's very different here is having regard to some of the matters that are being raised in this proceeding in relation to the Nayland reports. It's a very different factual matrix that the board acted under, and certainly the auditor, the investigator and the external manager acted on. There were significant concerns that were raised in relation to unqualified persons engaging in legal practice.
But this is all a question for the evidence, isn't it?
It is, but if we're operating on, the plaintiff's evidence hasn't necessarily been refuted or is not being denied here. We also still have evidence that was filed on behalf of the defendants in this proceeding. The answer to your Honour's question about the utility or the public interest would have to turn upon the particular factual matrix as well, and this is a factual matrix that includes these concerns about unqualified legal practice, the operations of the law practice itself, Mr. Cucchiara's involvement and Ms. Zhu, and Mr. Ansell's involvement in the law practice too.
But aren't you just saying you're going to win the case, which is not what I'm dealing with today?
Well, no, but it turns to in terms of the public interest. So if, say, for example, we lose in relation to the, somehow for some reason hypothetically the, all three, the auditor, the manager, or the investigator and the external manager, were appointed for some sort of improper purpose.
In broad terms, the allegation's going to be that they had taken a dislike of Mr. Cucchiara, or they had been told to take a dislike of Mr. Cucchiara and adopted that, and they did this not for the purposes of managing the legal profession but so as to harm him. Or harm people shop and indirectly harm him.
Yes. And somehow in conjunction with a variety of other state and private actors, the board also determined to do so. That's as I understand it's being put.
Yes.
The public interest or the utility would still not arise in the sense that on a strict legal sense there is nothing that would come from a purely hypothetical question or a declaration or an order that has no foreseeable consequences. The three appointments, the auditing, the investigating, the managing, have ceased.
Yes, but in Ainsworth there was no foreseeable consequence of that declaration save for the fact that it made it clear to everybody forevermore that he was denied natural justice when that finding was made. If the plaintiff succeeded in establishing that, then there would be a declaration that the board had acted unlawfully to damage the.
But sorry, I don't mean to talk over your Honour.
Would that not be enough?
No, it would not, because the issue in Ainsworth there was an issue of individual plaintiffs. It was those individual persons who were denied that because of the reputation.
Well, the company, People Shop Pty Limited, might have an interest in, if it's the entity with the right to say, look, come along and saying, we did nothing wrong and.
Well, yes, the company through the law practice did nothing wrong, and I think that's the distinction to be made, and I'm not certain that the court would find that the company has in and of itself a reputation at law that must be protected via some sort of form of orders or declaration.
So suppose tomorrow the Victorian Legal Services Board appointed people to a law practice for the purpose of causing harm rather than for the purpose of regulating the legal business.
Yes, I understand.
Would anyone have a remedy?
I understand that there was a matter the other week very recently in the practice court in relation to that, and the proceedings were filed by both individual person in relation to that individual practicing certificate and by the company acting by a solicitor in relation to the decisions of the board in relation to that company.
So the company would have, so why would there not be an interest? Why would not the company, here People Shop Pty Limited, have an interest or the public have an interest in obtaining a declaration that people had been appointed to People Shop unlawfully?
I don't say that that doesn't exist. Certainly the company would have that interest, I accept that. The point that I make in relation to that is to rely on the irregular participation.
What I'm saying, interest to get that, an interest sufficient to found a declaration even after the appointments have come to an end. I accept that they would have an interest, yes.
Yes, all right.
I accept that the company, if its participation was regular, would have an interest. I do accept that. The issue that I've raised is in relation to the foreseeable consequence of any such declaration. Yes, all right.
Yes.
If you, just whilst we're on these paragraphs 1, 2 and 3.
Yes, Your Honour.
And I said I was talking mainly about paragraph 1, and I was. Paragraphs 2 and 3 are seeking declarations, as I understand it, of legal rather than factual conclusion, if you like.
Yes.
Saying that the appointment reached its natural conclusion.
On the first Nayland report, yes.
Yes, and that there would have been necessary to have a fresh appointment of an external intervener. I'm really throwing it open to you for comment, in a sense. I see that as a bit different to paragraph 1.
Yes, I think the other thing in relation to this is, of course, and I don't have the date in front of me, that Mr. McGregor also ceased employment with the law practice at a certain point. That it seems to be that question 2 really turns on this interaction of the purpose for Mr. Nayland's appointment as an auditor, as opposed to, then, his first report and what it is that he determined in relation to Mr. McGregor. It kind of seems, in some senses, there is an allure or an attraction to what's being put here in question 2 because it says very clearly, well, Nayland was appointed to look into Mr. McGregor. He met and spoke with Mr. McGregor, wrote a report, and then that's the end of his appointment. But, of course, that can't be correct in the sense that it is Mr. Nayland's, as the second and third Nayland reports make clear. He was still investigating whether, he was not in, I'll just rephrase that. There's not an investigation into whether Mr. McGregor had capacity, but it was an investigation to Mr. McGregor's responsibilities, that he was discharging his responsibilities and duties as a principal in relation to the law practice. So, in that sense, Mr. Nayland at his appointment could not end merely after he spoke with Mr. McGregor, because that would have meant that he would have had to close his eyes, so to speak, to the actions and the affairs of the law practice to which Mr. McGregor was the principal.
Yes.
He was, indeed, in my submission, duty-bound to inquire into the law practice's affairs in order to ensure that Mr. Nayland, as its principal, was certainly discharging his duties properly under the uniform law. So to say that it reached a natural conclusion at the first report, merely after one conversation with Mr. McGregor, can't be correct.
Yes, but this is the argument on the merits of the point.
Yes, I accept that.
Well, what about, when one decides, to the extent that I would in this, which I probably would, in this suggestion about whether there's some fancy behind the allegations, it is a concern, isn't it, that a current affair were there when the board's representative, Mr. Rapke, took over? I mean, that raises a question to be answered, doesn't it, about why the press were involved?
It raises a question to be answered, Your Honour, but, fairly, I'm not sure it's a question to be answered by either Mr. Rapke or the board. There, as Your Honour, I apologise. I'm not sure whether videos have been played in this proceeding, but I've certainly watched videos, and Mr. Cucchiara's referred to videos.
Yes.
That he or someone else or Ms. Zhu took. And, I apologise, I'm not sure if it is Ms. Zhu, but there certainly were videos taken.
No, there are videos of it happening. I know.
Yes, and as those videos depict and make clear, there were a number of other actors who were present at the premises, and those include private security guards, as I can make out, and Victoria Police. So to say that the decision of the press or the person who must answer to the press is Mr. Rapke or the board, I think, would have to mean that everyone would be blind or ignore the various other actors who are present.
But going back to my point about whether there's some public interest in the court making declarations about whether things were done for a proper purpose or not.
The issue of
it adds some weight to what Mr. Cucchiara says, that this was done with a view to embarrassing him or the company.
But that assumes the connection that it was Mr. Rapke and or the board have had anything to do with the media.
Yes, it assumes the possibility of that connection.
And I don't think that's a safe assumption to make, that there were other persons who were present and involved, including, for example, Victoria Police, or private security guards.
Yes.
I mean, I don't wish to give evidence from the bar table, but the involvement of the media in a variety of circumstances, whether they're civil investigations or criminal investigations, is well known, unfortunately. And it is not apparent, either in this context or a variety of others, how it is a variety of media personalities or cameras get to know information or arrive at certain places.
Were they invited into the premises? I can't remember. I mean, once Mr. Rapke took control of the premises, he would have had the power to say to cameramen from Channel 9, "Get out of here."
I would assume so. I don't know from Mr. Rapke's perspective.
It's my personal phone, don't touch me, please.
Got no interest in touching you.
All right, great, thank you.
You create problems for no good reason. You're out of line.
Is there anyone else in the office who
No.
I should speak with about the appointment
There
of
is
the manager?
no
You are the
other.
only person in the
Yes,
office?
yes.
All right, well, there's no one else to speak to. I'll introduce you to Mr. Rapke.
I'm not interested in knowing him.
Well, I'm not interested in what you're interested in. I'm telling you, under the Act, Mr. Rapke has been validly appointed.
Sorry, okay, does he have a name card or something? And are you guys inviting Channel 9 in? Just asking? You are? Sorry, your name? I can't remember. Yeah.
My name's Howard Rapke.
So they've, just stepped in, so you've invited them in?
Guys, just give us a few minutes and then we can talk to you further. Have a look at these. Perhaps put your phone down and show some common sense.
I will give you 5 minutes to
You're
pick
obliged
your
to leave.
personal things and then you will leave.
Take your
Unless
personal
you
things
call the
now.
police, I am not
The
leaving.
police are here.
here.
They're standing to your right.
Where?
This is Detective Guerin and this is
All right.
Detective Homburg.
Take your personal possessions and leave.
Hello. Madam, you have 5 minutes to get your personal belongings and then you will be escorted from the premises. Do you understand that?
You're now trespassing. Your permission to be here is withdrawn. Leave.
The time starts now. You have 5 minutes.
Kylie, could you just escort her off the premises, please?
We'll give her 3 minutes. Let her collect this.
I'll tell you who I am. So my name's Tim Gear and I'm a detective sergeant with Victoria Police. So our role here today is just to ensure that there's no breach of the peace occurs. All right. You've been directed though by the manager now of the law firm to leave the premises. So if you could just pick up whatever personal items you have, and then we'll escort you off the property. Okay.
Well, what if I need to come back and get more stuff?
You can notify the manager and make an appointment with the manager. Will
I don't have his contact details.
Oh, we'll give them to you. That's fine. What's your name, ma'am?
Lulu.
Lulu, so do you just want to collect your personal
Lulu,
property?
before you go, a couple of questions. Thanks, Tim. Appreciate your help. A couple of questions. And you're obliged to answer them.
I'm not obliged to answer you any
You're
question.
obliged to provide information to me as manager. There are numerous computers I can see within the office. Before you go, I would like the passwords and entry codes for all of the computers.
I don't have that.
You do not know how to operate computers in this office.
I do not have the passcode.
You don't have the passwords.
No.
Who does have the passwords?
I don't have the authority to tell you. If you want to exercise your power, you can do that, but I'm not an authorised person to tell you
so you
that.
understand, under the legislation, obstructing the manager is an offence. Do you understand that?
If I don't know, I can't tell him.
I'm just letting you know. Do you understand that by obstructing the manager, that's an offence? Do you understand that?
How did I obstruct him?
He's just asked you for information.
Yeah, I said I don't know. No, I do not know.
You don't know?
No.
What do you do here, Lulu? How did you get in here?
I'm sorry,
Well, you don't have to answer
It's,
those questions.
yeah, yes,
Pardon me.
no.
All right. Have you got all your belongings?
Sorry, what's your name?
I don't say mine. Have you got all your belongings?
Well, stay there.
You can leave the premises now. That's a formal request as manager.
Okay, but when can I get a receipt of stuff?
You'll get a receipt in due course, and I'd like to have a look at that red folder before it goes anywhere, please.
Well, your staff was just looking at it. I have shown to her. Please ask her. You
I will.
show some respect.
If that's the case, I'd ask you to leave the premises.
You see the red folder?
Yes,
I'll
that's
see.
my own staff. Can you please ask the girl? Are you guys
Excuse me.
like?
Out. Out.
Lulu, Sam Cucchiara from the Current Affair. Did you think this day was going to come? Where's Shivesh? Lots of families have been harmed by Shivesh and his companies. Anything to say to those families, those hard-working families? Why are you
Do
covering your
not
face?
harass me.
I'm
Do
not
not
harassing
harass
you.
me.
Why didn't
Do
you let the
not
investi-
harass me.
Why didn't you
I
let the
feel scared.
investigators in?
I feel scared.
We've got police here. You didn't
I
let
feel
them in.
scared. Where's the police? I feel
shouldn't
scared.
feel
Do not
scared,
harass
Lulu.
me. Do not harass me. Don't
Why
come
didn't-
in. Why are you
didn't you
coming?
let the investigators into your office, Lulu?
Do not harass me. I'm asking you to not following me.
Well, they've asked you to leave. You haven't done that.
I'm asking you to not to following me.
Is this the end for Shivesh? Will he be starting a new company? Is he masquerading as a lawyer?
I'm
Lulu?
sorry. Why are you harassing me? You're making me scared. Can you please just stay away, please?
I'm nowhere near you, Lulu.
Can you please?
Where's Shivesh?
Why are you
Will he
following
talk
me?
to us? He loves threatening people in court, but he's too afraid to talk to us. Is that right? Is that
You
right?
talk to her. You talk to him as you want.
Well,
I'm
sorry.
asking you to leave me alone, please.
nowhere near you,
Okay.
Lulu.
So when I step into the lift, will you follow me?
Why didn't you let the investigators
Will
inside?
you follow me?
What's Shivesh going to do now? Try something new, maybe.
I asked them 5 times, can you not let Current Affair in? And they,
Ms. Zhu, it's not your turn.
sorry.
Ms. Zhu, it's not your turn to talk.
The issue here is that we, then, are rolling into, in my words, issues about the improper nature and this grand conspiracy that is being put by the plaintiffs against all of the defendants. And, somehow, the involvement of presence of the media on one particular day is indicative of that.
Yes.
Where there is, certainly, nothing that suggests, this is an evidentiary point, but nothing that suggests that that is the case. But even as a matter of form, these are, in some senses, require factual findings. They seek to preempt a variety of other types of claims or causes of actions that might come in the future. Things like, as has been indicated, misfeasance in public officer or a variety of tort.
Yes. Well, look, I've distracted you, so if you want to move to that aspect of it, do. So we've dealt with the standing argument, have we, and the question about your point that everything is in the past?
Yes.
All right.
And the appointments have ceased. And I understand that Mr. McGregor's employment was terminated by the law practice in early November, and that's contained in the third Nayland report.
Yes.
Putting aside, for one moment, the issues of utility and the reasons, or the improper purpose which I would say these proceedings have been commenced, there's also the next submission in relation to an abuse of process point that's been put in relation to concurrent and multiplicity of proceedings.
Yes, but how does that work? Why don't they get struck out and this proceeding continue?
As I understand it, I think the majority of them have been temporarily stayed. And so, but they are.
Just conceptually.
Yes.
I agree that there's a potential problem if proceedings are being brought in different cases. Different proceedings are being brought seeking the same overlapping, sort of, issues.
Yes.
But why does that mean? How does the court choose which one, then, gets struck out?
No, I think the answer is, firstly, as I understand it, having appeared in at least one, they are, in some senses, more progressed than this one. There's certainly been some stagnation to this proceeding where, respectfully, the plaintiffs have not moved much in the last 2 years. Whereas in the other proceeding, at least the one proceeding before Justice Ginane, and I think that is 04808, there's certainly been a variety of applications for the.
Is People Shop the plaintiff in those cases?
No, Mr. Cucchiara is in 04808, and in 00183 I will just have to bring up my notes.
According to your submissions, it just refers to Mr. Cucchiara, well, Mr. Cucchiara and Ms. Zhu in those other proceedings.
Yes, that's right, sorry, Mr. Cucchiara and Ms. Zhu in.
So if you're right that this case legitimately, at best, concerns complaints brought by People Shop Pty Limited,
then this argument falls away.
Yes.
I accept that, yes. The next point is, moving away from the evidence, just a point about the scandalous or convoluted nature of the plaintiff's claims within the originating motion and also their amended summons. Now, as part of the written outline of submissions, there has been prepared an Annexure A to that document which seeks to separate out, well, put in some senses, but work though a detail about the nature of the concerns of the originating motion and the further amended summons. If Your Honour has a chance just to turn that open, the broad points are, and I can take Your Honour through as to why, but certainly, the broad points are that the nature of the claims in the originating motion and the further amended summons are convoluted and aggregated. That is, they make a variety of claims, both grievances and various assertions, against all of the defendants, in some sense, without providing particulars as to either the cause of action against individual defendants or particularization as to what individual defendants have done, or even particularization as to how some of these grievances or assertions are made out, in terms of legal reasoning. So the starting point for the originating motion is under I, the plaintiff's claim, and then heading which is judicial review and declaratory relief. That's addresses at paragraph 1 of Annexure A, in terms of just trying to summarize and describe the nature of the alleged decisions or alleged conduct there. Including alleged, amongst everything else, contravention of Chapter 3 of the Commonwealth Constitution.
I've just noticed the time, Mr. McAuliffe.
I apologize, Your Honour. Yes.
Thank you, Your Honour. Now, Your Honour, I had indicated that I was going to seek to assist Your Honour just in relation to that issue about the company entity and legal status. I can say that has certainly been fruitful, so if I could just return to that briefly in terms of the regularity or not of the company's participation in this proceeding. Yes.
A decision of Worldwide Enterprises, the medium-neutral citation is 2009, VSC 165, by Justice Forrest, which looked at the purpose of the rule and the circumstances in which a company might be permitted to take a step without being represented by a legally qualified person. And His Honour sets out a number of matters and circumstances which should be considered in determining that issue. And here, of course, a number of those are relevant, and that would include, for example, the manner in which the case is being commenced and progressed, the complexity of the issues, whether the case can be conducted in an orderly and responsible fashion.
But hang on, if I let it.
I apologize, yes.
It's what's going to happen into the future that matters.
Yes, I accept that. And that's the point that I just to make here is that if Your Honour doesn't strike out or summarily dismiss these claims on the basis of the company's irregular participation, then Your Honour is still left with an issue here. We've got a very complex, on one view, proceeding that is, in my words, a rolling determination of a number of different facets and legal claims, which in my submission cannot be undertaken or conducted in an orderly and responsible fashion without a solicitor.
But I would have to deal with, cross that bridge if I come to it. If it gets to the situation where the company's the only party left in, then can I decide what happens next?
That's right. Now, the other following from that point, there is a judgment by Associate Justice Durham in Rossi Holmes, and the medium-neutral citation is 2018, VSC 95. At paragraph 4, the point is made that a company's status as a legal entity is a creature of law. Similarly, the law has imbued the company with rights and obligations. Now, then later in the judgment His Honour goes on to say at paragraph 6 that, apologies. I'll just take a step back from that, sorry. Just remaining at paragraph 4 for a moment in Rossi Holmes. The point is made that the company's a separate legal entity that is distinct from its shareholders and directors. And that's certainly the point that I was making just before lunch. Then at paragraph 6 a point is made that Rule 1.17 is really a restatement of the common law position about who should be permitted to appear before it, and in those circumstances, of course, who should be permitted to represent the company, and so the issue here is really, as I say, the companies that separate legal entity. It may have a separate interest in the proceeding, but thus far, its participation is irregular, and certainly, it's irregular despite being on notice of these matters for the past 2 years since.
Yes, so the commencement of the proceeding was no irregular, but no step has been taken, you would say, since then?
That's so. Now, just on the commencement issue, I don't mean to overwhelm Your Honour, but there is another case by Associate Justice Durham in Re AOA 2022 VSC 690. Factually it is a bit different, but interestingly in that one the proceeding was commenced by that company in a regular fashion. The company was represented by a solicitor, and then those solicitors filed a notice of ceasing to act, and here, of course, while there's been no notice filed of ceasing to act, Mr. Ansell is no longer permitted to act by the company because he doesn't hold a current Australian practicing certificate. Following application of what I would say are standard or orthodox principles, the decision was made to decline, I think it was a director, and/or secretary, to represent or to continue to represent the company in that proceeding. A new solicitor essentially was required, and so it's certainly not the case that Rule 1.17 can be circumvented merely because proceedings were initiated in a regular fashion.
I have to cross this bridge when it comes to it. The company might come along with a lawyer, or the company might come along and make application to be permitted to take a step without a lawyer, and I'll have to deal with that, but for the purpose of the strikeout application?
It is still relevant because the further amended summons were filed after Mr. Ansell ceased to hold an Australian practicing certificate. It was filed on behalf of all of the plaintiffs, and no leave was sought on behalf of the company for a dispensation under the rules, and despite these matters being raised fairly, no leave has been sought in the last 2 years.
So what does that mean? You say I should treat the summons as not having been, as the company has not been a party to the summons?
Yes, the summons has not been regular, and the company's participation in both the summons and the proceeding has not been regular, and if.
So the only thing that was done regularly by the company has been the filing of the originating motion?
That's so, and even if Your Honour, for example, is with me in relation to removing Mr. Cucchiara or removing the individual plaintiffs from the proceeding, then we still confront this issue about the company's irregular participation, but also vice versa. If the company is removed for its irregular participation, then we're still confronting the issues as I raised in the beginning, that those individuals would not necessarily have a stand-in or an interest in the outcome of this proceeding.
Yes.
So I think just before lunch we were just dealing with the nature of the originating motion and working through some of the matters raised in the annexure. Apologies. In Annexure A, and we were just discussing the ways in which, possibly, grounds 1, 2, or 3 might be dealt with separately, and other issues there. I think the difficulty conceptually is, of course, how, in a context of accusations of assertions which are complex in nature and very serious, how any of the defendants, the board, Mr. Nayland, Mr. Cooper, and Mr. Rapke, are to, and I use this word not necessarily in this formal sense but to plead or to respond to these various assertions. That is because they are aggregated. There's no distinct particulars that are going to be put against each and individual defendant. So if we have a situation where, let's say, we deal with grounds 1, 2, and 3, and hypothetically, the board is successful in dealing with 1, 2, and 3, then the question that I ask rhetorically, of course, is what next? Do we just work through grounds 4, 5, and 6 in their aggregated and hypothetical forms, for example, paragraph 6 of the amended summons seeks factual findings, and seeks to preempt other proceedings. This is paragraph 6 that relates to Mr. Cucchiara, no evidence being Mr. Cucchiara engaged in unqualified legal practice, and then 4, 5, and 6 are done, and then what next? We move on to the next 3 or however many paragraphs out of 30 or so, and, again, in each and every step the board would be dealing with, and that all defendants would be dealing with claims that lack particulars. That don't step out with any particularization how those claims are met. So just returning to the originating motion for one moment. If Your Honour might move to the second parts of what I call the second part of the originating motion, which commences from P7 of 14, and that's under Roman numeral number 2 the grounds relied on. These are, again, conduct that's alleged via these aggregated terms, serious LSB abuses, LSB statutory breaches, and at the end of the chapeau at paragraph number 1 under the heading, a contravention of statutory provisions, it's put against the defendants. The defendants, meaning all of them, have acted in contravention, and that's in contravention of all of those matters listed from 1.1 through to 1.17. Now, of course, it may be that potentially that the plaintiffs are making allegations against all of the defendants for all of those matters that, in what is technically a judicial review proceeding, is almost impossible, unintelligible in the sense of how each defendant is meant to be able to respond to each of those identified statutory provisions, particularly when over the course of the next 7 pages there's very little, if any, cross-references to those statutory provisions, and the plaintiffs don't make out or don't particularize how those provisions or how each or all of those defendants have apparently contravened all of those provisions, including, for example, International Covenant on Civil and Political Rights. Then, over the page to paragraph 8 under the heading of B. Abuse of statutory authority, the plaintiffs allege that, for example, 2.1, both LSB and Mr. Nayland either maliciously abused their authority or manifested, in distinct words, unreasonableness. It's unclear in relation to what act or actions are alleged against the board and Mr. Nayland as to that abuse of authority or manifestation of unreasonableness, as well as no particularization as to legal reasoning. What are the actions? How are they done under authority? How are they an abuse of authority? How are they a malicious abuse of authority? And that's giving malice, in that sense, its legal technical meaning. Again, moving through paragraphs 3, 4, 5 and 6, where there are a number of claims which are apparently put against all of the defendants. Matters in relation to the compliance audit and the service of the notice of the compliance audit, as well as VLSB's apparent justification in authorizing a compliance audit. Which in some sense seems to link to paragraph 2 of the amended summons, but in other senses it doesn't, because of the way in which these aggravated claims are being put against all defendants. Over the page, for example, 2.
Are you saying, though, that you just need more particulars? Or are you saying that this proceeding can't be brought by originating motion because it should be brought by writ, instead? Or there needs to be a pleading? Or are you saying, just get rid of it? None of that matters?
Well, the easy answer is the latter, in the sense of, get rid of it all. Because it's impossible to respond to.
Yes.
But in fairness, this is a discussion which we have been having in an ongoing sense. How is it possible for anyone, let's just take the board, for example, to be able to respond to this? Some of the claims within here are claims of tort, misfeasance in public office, possibly negligence. In some senses, those claims or causes of action are real, are legitimate and known to law, and they should be commenced by a statement of claim. There should be pleadings. There has been a question ongoing about, and I emphasize that this is not something that is sought today, but if, in some form, the originating motion or the further amended summons does proceed, whether or not there should be some form of pleadings ordered so there is a way in which those matters or those particular claims can get to trial. Because at this stage, in a judicial review proceeding, the board and or the defendants are going to have to front up at trial, in some way, to defend on the.
Well, one of the things I have to do is try and work out what this proceeding is. Because you're right that the originating motion expresses itself to be an originating motion for juridical review and Part A is headed, Judicial Review and Declaratory Relief, but then it does seem to move into non-judicial review aspects.
Yes, so if Your Honour just had open, and maybe, if possible, together, but annex your A to the submissions, we had attempted to summarize the three parts, parts A, B and C, of the first part.
Yes.
Part A is certainly judicial review and declaratory relief, but then Part B, which I have skipped over, in terms of oral submissions, references, equitable relief, and that refers to things such as release of documents, intellectual property, provision of information. There is also reference in there, under equitable relief, in relation to indemnification of plaintiffs, restitution, counterprofits. Somewhere within these claims, I don't have it in front of me, there are also claims in what might be called conversion or detenue, where the plaintiffs seek return of goods that apparently were taken at some point. It is rolling, in that it is seeking to review a variety of not only decisions but ACTS and actions across a variety of causes of action. Now, some of these claims are legitimate in the sense that they refer or might be taken to mean lawful or legally known causes of action, but they are all in one document, all under a judicial review proceeding. That's B, but then Part C, which commences from P6 through to P7 of the originating motion, is also headed or refers to Order 56 feet. I take it to mean it is judicial review, but it seeks, within Part C, also, for provision of information for orders that the defendants undo things. Undo this so-called Cucchiara promotion, and also undo registration matters relating to Mr. Ansell's practicing certificate. I identified why, in those written submissions, in a judicial review, those provisions that are sought to be relied upon by the plaintiffs under the uniform law are not available to this court, but certainly might be available to this court following an appeal from the tribunal in relation to Mr. Ansell's practicing certificate. I can address Your Honour further on that as an issue.
Yes.
So just very briefly, I think that, in the written submissions, apologies, Your Honour. Thank you to my instructor. I think it's P7 of the written submissions, at paragraph 29, which just refers to and cross-references S464 of the Uniform Law. As identified there, when the provision is read properly and in context, it doesn't permit this court, on judicial review, to seek to do what the originating motion seeks. That is, on a judicial review to renew the registration of Mr. Ansell's practicing certificate. Just returning to that second point that I started off with, when we actually come to looking at how will this matter be ready for trial and how do we progress through some of these claims, because of course, you know, the court is able to separate off and make orders in relation to the trial of certain claims in advance. But once we start, in my words, sorry to use this, unpacking some of these claims and really looking at what evidence is required and what might be required in relation to responses or pleadings and inquire into these various claims in the originating motion, that is when the aggregated nature of them is revealed, and that is when it is apparent that there are a number of different types of claims, as well as just general grievances and assertions being made against all the defendants.
Yes.
So moving on to P9 of the originating motion. That's where one of the headings, circa, conspiracy to violate the plaintiff's rights, I say that it's very apparent that what follows is actually not any allegation of conspiracy known to law. It includes allegations about the first defendant, the board, and possibly others, having acted in breach of the separation of powers between the executive and the judiciary. Now, that conclusion is not found until P12, at paragraph 25, but that's certainly the thrust of the narrative that is being put forward. If your Honour turns over the page to paragraph 17 on P10, this is somewhat unique in this originating motion. What occurs in paragraph 17 is really what could only be described as a narrative where the directions that were issued by.
Paragraph 17?
That's so, yes.
Yes.
From P10 of 14.
Yes, I have that.
What occurs in the chapeau is that reference to the MSDs, which I think has been defined earlier in relation to the directions that were issued by Mr. Anstey on behalf of the board and its effect or alleged effect on the operations of the law practice and apparently any performance in proceedings and interests of clients. And then what unfolds over 2.5 pages is this narrative about how these directions apparently had those alleged effects, implementing some sort of higher or harsher standards. At paragraph 17.3, demanding greater visibility into the firm's affairs. 17.4, creating additional compliance burden and thus reducing the firm's resources for productive work. I mean, this is a narrative being put in the originating motion that doesn't appear to have a grounding in any course of action. And certainly is not particularized, or it has no reasoning about what it is and why happening. What are these ACTS or actions apart from the fact that the directions were issued, that had this impact or this alleged impact? And then, again, at paragraph, over the page, to 17.6. The introductory sentence there, providing the LSB with additional opportunities to intimidate, coerce, incite or collude with any disgruntled employees of the firm against the interests of the firm's clients. It is unclear what that means. It's convoluted. It's unintelligible in the sense that the board and its defendants can't respond to that in any meaningful way. It doesn't appear to indicate any form of course of action, but it still continues in this narrative sense. The prejudicial following paragraphs refer to alleged prejudicial impact, references to the prejudices created by the board on the law practice and its clients. And then just before we get to 17.7 there's a comment, in return the LSB exploits the nefariously fabricated allegations made against Mr. Cucchiara and the firm to make prejudicial decisions and enforce punitive measures against them without providing them an opportunity to address allegations. Even accepting, hypothetically at its highest, that there is something there, it is totally unclear that this is anything more than a grievance, a mere assertion. It is wholly unacceptable in the sense that there is nothing that provides a framework or a pathway of reasoning to that conclusion. It is impossible for my client to be able to respond to that. And in that sense it has to either be described as scandalous or frivolous or vexatious or all of them, but it is certainly a part of this narrative within paragraph 17 that culminates over the page with these allegations that are not only vague, but really in many ways meaningless about breaches of separations of powers. Breaches of rights of individuals and apparent corporate entities that are implied in Chapter 3 of the Constitution. That reference is found on p12 of paragraph 26. There's allegations that somehow follow this narrative within this subheading, Part C of a conspiracy, about, Your Honour will find them at paragraphs 18, 19, and 20, which have less of a narrative flavour, I have to say. But still lack the basic questions of how and why. The Rapke appointment was not in compliance with those sections of uniform law. How is that put? Or why is that put? Section 336 did not authorise LSB or Mr. Rapke to effectuate the erudite legal heist. Putting aside that defined term, again there's no explanations of how or why. Paragraph 21, decisions made not to review, apologies, not to renew professional indemnity insurance. Let alone whether that such decision is justiciable, it is wholly unclear about who's that with, that put against. Is it put against all of the defendants? If so, how does that amount to a conspiracy? This is still under Part C, which is the conspiracy. And how is the board or any of the other defendants meant to plead against that? Or meant to be able to respond to that in an intelligible fashion ahead of trial? Paragraph 24, for example, excuse me, Your Honour. Decisions in relation to instructing solicitors to oppose certain subpoena applications, it seems to be allegations of some sort of misconduct. Again, still within a conspiracy claim and still in Order 56, judicial review. How even at a base-level decision to instruct solicitors can be said to be public misconduct, let alone how it can be said to be public misconduct.
I don't think it's the fact that they instructed in the sense of engaged court chambers with, it's that they gave instruction to oppose the subpoena applications.
Yes.
So it's really the opposite. How I read that is
The opposition.
the suggestion that it was the opposition to the subpoena applications that was public misconduct.
Indeed. But how the board is meant to be able to engage in some intelligible fashion with that allegation in an Order 56 judicial review is impossible. If that such a decision is.
I'm going to have to work out what this proceeding is, in a sense, aren't I?
Yes.
I mean, it's at least in part an Order 56, but it does seem to be endeavouring to go beyond that to try to get the declaratory relief related to Broad. The proceeding seems to have been commenced on the basis that it's appropriate to issue an originating motion seeking declarations that various people have engaged in misconduct.
Yes.
That is that if people have engaged, the argument I understand that's going to be put is that if people have engaged in misconduct, then the court should make declarations to that effect, and the proper process by which this achieved is by filing an originating motion. And I have to see whether that's legitimate or not.
That's so. And I think if I can piggyback off that comment, Your Honour, the issue in there is twofold. The first is, on one hand, the court might be able to look at paragraphs 1, 2 and 3 of the amended summons and say those are matters about, it could be said, public decisions or decisions made by public authorities, but then what Your Honour has just referenced is something slightly different, but importantly so, is allegations of criminal or civil wrongdoing. That is, the plaintiffs are seeking essentially for the court to adjudicate in some way via declarations or via that form or remedy criminal guilt in a civil proceeding. It is not unknown, but if that is, it should be reserved only for the most special or exceptional cases. And if that is certainly what is sought by the declaratory relief for this court to adjudge guilt, criminal guilt in a civil proceeding via the making of declaratory orders, then the matters which are put in the summons and originating motion do not suffice in any way for those against whom declarations are sought to be able to properly and fairly respond.
I want you to address one aspect. At some stage Mr. Cucchiara, I think it was Mr. Cucchiara, said that the utility in getting declarations of wrongdoing is that then operates as an issue estoppel that can then be used by the plaintiffs for whatever purpose they wish, including commencing of other proceedings and so forth. If that's what is put forward as the justification for the way the proceeding has been put together, what's the board's response to that?
It would, in my submissions, be a borderline if not an actual abuse of process, because the proceeding should have been properly commenced by a written statement of claim rather than seeking declarations without and via a different procedure that doesn't necessarily involve pleadings, and essentially, under Order 56 evidence only on affidavits, it's not an appropriate. Order 56 judicial review is not an appropriate vehicle for any or all of the plaintiffs to use it as to bring a variety of claims, whether they be for declarations about guilt or wrongdoing or even something such as return of practicing certificates or malicious actions or ACTS taken by some or all of the defendants.
So if they want to bring a damages claim against somebody, they've got to bring a damages claim against him, you would say?
Yes, indeed. If there's a negligence claim to be brought, then they bring a negligence claim.
And not get a declaration of unreasonable conduct, and then use that to found a subsequent?
That's right.
I can see that there's traction of that way of thinking to the defendants, but are there authorities that you can point to where this issue has been discussed or explored?
I don't mean to laugh, Your Honour, but the only authority that I have in recent memory is an authority involving Mr. Cucchiara by Justice Ginane, which is referenced, I think it's 04808, and if I have that correct, which essentially is in the context of a temporary stay application which was granted in relation to those claims made against the board, but His Honour does go on to say and make some very pointed remarks in relation to concerns about using Order 56 and declaratory remedies issue estoppel or to bolster or to preempt those types of claims, and I might just.
What is the citation of that one?
If Your Honour would just excuse me one moment. Should be on P6 at footnote 22. There is a reference to 2 citations there.
Cucchiara, yes.
And I just don't have it open in front of me, but certainly, from memory of that judgment, His Honour certainly does inquire further that as an issue, and canvasses some of the case law in relation to Order 56 as a vehicle. Now, I'm certainly not saying that applies wholly by analogy, but it certainly does apply in the sense of Order 56 and seeking declaratory relief and its appropriateness or otherwise in relation to other types of claims. And then just finishing on P12 of the originating motion, just in those final 2 paragraphs 25 and 26 which I alluded to early, there are claims being made variously against the defendants about infringements of rights, economic interests, and breaches of separation of powers. Again, these are, in some ways or very straightforward ways, bold assertions that are essentially meaningless for the defendants to respond to without firstly, identifications about what are these rights, what are these interests, or identification about how they apparently have been contravened, and the same goes in that sense in relation to paragraph 26. Now, that brings us to the end of the originating motion in terms of that detail, but I would note, and I won't go back over it, but the next should be that the written submissions outlines those matters which are said to be scandalous in a sense that a number of allegations are put against various, not just defendants, but also former employees of the law practice across the originating motion in some detail, which without reference to the evidence, but certainly don't particularize or don't engage in any sort of legal reasoning pathway how those matters are sustained against those individuals. And just turning briefly to looking in some detail the further amended summons. If Your Honour has that in front of you, Your Honour, we've already discussed paragraphs 1, 2, and 3, and the issue with the chapeau to the entire summons. Turning to look at P2 of the further amended summons. Paragraphs 4, 5, and 6. Again, we have issues that are, in essence, either hypothetical or attempt to preempt other proceedings as we've discussed. Then we have a matter such as paragraph 8, by way of example, seeking to determine and declare that in view of the circumstances prevalent at the time. Again, the circumstances are not set out. It was not improper for Mr. Peter Ansell to be hesitant to comply with instructions of Mr. Nayland, and Mr. Cooper will be unwilling to engage with them in accordance with their agenda. It seems on one view of the matters that are set out in Mr. Nayland's report that goes to matters that referable to Mr. Ansell's suitability.
So what is the problem with paragraph 8? Are you saying it's asking the court to make declarations that the court would not make because the court
would have to make factual findings?
Because it doesn't matter, or what is the problem with it?
The problem is that the court would have to make factual findings in relation to what was done by each of the three, Ansell, Nayland, and Cooper, and then the court would need to ascertain whether there is any reasons or whether it's in the public interest to make such declarations, and the court would need to inquire into whether, even at a base level, Mr. Nayland and Mr. Cooper were public authorities or acting as some sort of a public entity as opposed to acting merely under some form of statutory appointment or power. Paragraph 9. The court would be confronted with similar issues in relation to having to look into and inquire into all the Nayland reports to determine whether Mr. Nayland had prejudged matters, 9.2, was biased against, denied him procedural fairness, or being, over the page, motivated by an improper purpose, or has suffered from unreasonableness. Again, I accept that something such as bias or procedural fairness might be properly matters for judicial review, but the ways in which paragraph 9 is being framed, prejudgment, improper purpose, is really going beyond just whether there was bias or whether he didn't give Mr. Cucchiara an opportunity to respond, and would require the court on judicial review to make findings of fact. It might have to hear evidence from Mr. Nayland for him to be cross-examined, and then.
That's okay, isn't it?
Well, not in the ordinary course of judicial review events. It really would seem to be a proper matter for a statement of claim if what's being properly alleged is some form of negligence or misfeasance or malice, as opposed to merely, as an auditor, going in to investigate Mr. Alan McGregor and his conduct as principal, and, as the reports make clear, made attempts to contact and speak to Mr. Cucchiara.
So there's the point of what we're talking about before.
Yes.
If they've got a beef with Mr. Nayland commencing the proceeding for whatever, for damages or whatever rather than a.
Paragraph 10, I think I would have to accept, is a bit more straightforward in the sense of being a matter which it was a decision issued by the board, and in that sense it is being justiciable, but the question that it then arises is either the utility of it because they're no longer enforced, and also, whether once everything else falls away whether there's certainly any purpose into that inquiry because it's unclear on the face of that summons. Sorry, I'll take that back. Looking at it in that very isolated format there, again, is that attraction to, well, that's a very simple matter. That should just go be heard at trial, but the issue on reflection with the originating motion is that what sits behind paragraph 10 is, of course, this narrative of those management system directions have caused adverse effects on rights, interests, economic issues, and, in my submissions, what's apparent from how the plaintiffs are putting their case or cases in the originating motions is that paragraph 10 and other paragraphs cannot be so simply carved out because the reasons why they're bringing them, and what they're being sought, and what would be argued, based on these documents, is something much more complex than merely whether the board had power or not to issue those directions. Paragraph 11, again, makes, in my submission, well, whether or not the court could even make such an order, but it's impossible to respond to because it seeks an order that the defendants refrain from taking any further steps to interfere in any court of tribunal proceedings. There's really little utility in that, but there's also no clarity about what other proceedings might be on foot apart from the ones which the board is, in essence, being joined to or being named as a defendant. Paragraphs 12 through to 16 seem to be some form of discovery or preliminary discovery. There are orders being sought for the release of information or for the defendants or the board to provide information to the plaintiffs. Again, this comes back to the convoluted nature of these documents. If this is to be an application for discovery or preliminary discovery, and that's something also that Justice Ginane dealt with in that other proceeding 04808 where orders for discovery was sought against the board. That is a matter that should be properly run as a separate summons, an application, and there should be a sufficient and identifiable basis for that discovery. But here the problems with 12 to 15 to 16 I'll come to in a moment, really seems to be that these are not properly formed order for the discoveries. They are really orders that would be consequential to success in the other claims that are being brought against the board. That is, once successful, the defendants must inform the plaintiff of these such matters or release such matters. Now, it might be that I'm wrong about that and the plaintiffs want all that information now, and in that case, it's better described as an application for discovery. Order 16, in essence, seems to be some form of injunction that is being sought against the board, refraining it from using any such information obtained to the so-called escape proceeding information. Again, it's hard to understand the basis for such an order that's being sought. Indeed, there is no basis that has been put forward for such an order. The paragraphs 17 and 18 we return to some form of discovery or subpoena that's being sought for requests for information being sought against the defendants, and 18 refers to Mr. Rapke specifically, and even putting aside such matters such as the court's jurisdiction to be able to deal with these sorts of requests in this type of summons or application, we're still at a point where if we work off subpoena principles, it's, very much on its face, a fishing expedition, but if we work off discovery principles, it's not apparent how such matters would be relevant at this stage to the claims that are being brought by the plaintiffs because it seems, as they've said, I think, in this proceeding at least, hand in hand that they've made these claims, and they're trying to access or seek to access to other information or other documents which may or may not exist, which they say certainly may or may not, or they say that would exist, and I apologize. If I might just return to a different matter, Your Honor? My instructors just corrected me that Justice Ginane dealt with the discovery issue in a different proceeding which we call Counsel and Miak, and the citation for that case is 2023 VSC 624. That is referenced in the written submissions still, but it is, unfortunately, just over the page at footnote 20. I apologize. So the discovery was dealt with by Justice Ginane in the Miak proceedings, not the State of Victoria proceedings.
So footnote 20 of your submissions?
That's so. On page 5.
Yes.
So I think it's at paragraph 107 Justice Ginane, in the Miak proceeding, dealt with the issue of discovery there. The situation, as I would put it, that the plaintiffs or at least Mr. Counsel, who's certainly in a variety of proceedings, trying to get access to or get at information or documents which he says exists and has not been able to articulate either they do exist or the basis for any access to them. Returning just to the summons and going over the page to P4. Paragraph 19. Respectfully, I've had very significant difficulty to make submissions about paragraph 19 because on its face it is extremely vague. It is certainly unclear about the nature and form of the declaration that's being sought or how, for example, in the middle of it says, Mr. Rapke and Alice B had functioned as a collective de facto managing director of the firm, and had attracted their obligations and liabilities in respect of any prejudice directly or indirectly caused by their actions. I mean, on its face it really is this issue estoppel again. The declaration is being sought against a variety of actors to essentially, one would assume, found a claim or a different type of claim in a different proceeding, but regardless, it's unclear about what are those prejudices, what are those obligations and liabilities that are being claimed. We then come to a variety of orders. Essentially, from 20 through to 24 which, in my submission, there's a serious question about whether the court would have jurisdiction to be able to make such orders on judicial review or to the LSB to promptly remove all publications concerning the plaintiff on its website. 2. Retract or retweet a tweet. I assume that's a reference to what used to be called Twitter and is now called X. Issue apologies. I assume that's apologies to all plaintiffs. Paragraph 23. The court to instruct its CEO to investigate matters in relation to the LSB's improper or unlawful collusion. So I'll just pause there for a moment. So not clear what the basis is for such orders, what are those publications or tweets, so to speak, or even how the court has jurisdiction to be able to make such orders. They really lack sense. I mean that by that it is almost impossible for the board or the defendants to be able to respond to such matters. We then come to paragraph 24, the LSB cease and desist from pursuing any investigations of alleged summary offences being pursued under the Criminal Procedure Act. I cannot understand how, under any of the established or orthodox categories of judicial review, such an order might be made to prevent any person or a regulator from investigating or pursuing investigations in a criminal matter. Regardless, it's put wholly without basis or without a sufficient pathway of reasoning as to why that order should be made. Order 25 I've already addressed in relation to this court's powers under the Uniform Law, separate to its powers under judicial review. That is, this is not the appropriate vehicle. This proceeding is not the appropriate vehicle by which a court may order or should order the board to renew Mr. Ansell's practicing certificate. 26. Again, not only does it lack utility, but it's, in essence, vague and unhelpful in that it requests an order that the defendants cease and desist from interfering in the operations of the People Shop. Obviously, any such interference which we say or I would say is lawful has already ceased, but the order goes further and seeks that the court restore the plaintiffs to their original positions prior to the interference. Fairly, I would see that as a request for damages. Otherwise, if it's not, it's unclear and very vague as to what these original positions are. Paragraph 27 seems to be referable to Mr. Ansell, so I'll just move on. And paragraph 28 refers to this apparent incident that occurred in relation to a matter that I was not across, Justice Whelan's decision or this matter in particular. But, in essence, just as a matter of form, this is unclear what is being sought because after this very long introductory sentence on the second or the third last sentence, we have a comma and then it says, the LSB's conduct has revealed that the appointment of Mr. Nayland was motivated by an improper purpose and not simply the reason provided to the firm. That, in any view, is pleading and appears to be a pleading relating to or some form of misfeasance or misconduct in public office. And then we come to the final matters which I can deal with concurrently. So paragraph 29, which goes over the page and has 6 sub-paragraphs, again, these matters are unspecified, aggregate the allegations against each of the defendants, are convoluted and really go to this issue about seeking factual findings in one sense to be able to form a basis for an issue estoppel.
So this is where the improper purpose is expressed, it seems.
Yes, it does, indeed.
So the way it might be understood then is in a sense, these are the grounds that underlie paragraph 1 of the amended summonses, that paragraph 1 says make a declaration that the board had an improper purpose and the sort of grounds for that this is what we say its purposes were.
Yes, I'm with your honor. I understand, yes, that's one way of looking at it.
Yes.
And I think it's certainly open to look at it that way. It unfortunately just brings us back to that original, or one of the original submissions about the use of a judicial review proceeding as a vehicle for these other matters, because on one view, yes, it's a very simple, the appointments were made unlawfully or illegally or in the sense without statutory imprimatur, but in the other view, it's they were being made for purposes that were directed to vilify Mr. Cucchiara or motivated to unlawfully restrain Mr. Cucchiara. And in that sense, we really are in a different form or a different nature or type of proceeding than judicial review.
Yes.
Yes.
Right.
That brings me to the end of some of the detail in relation to how claims might be said to be scandalous or frivolous or vexatious. I've already addressed your honor in relation to those matters that are a separate point in relation to the use of these proceedings to adjudicate criminal guilt by declaratory remedies. And certainly already addressed your honor in relation to the abuse of process issues. I think the only matter just to touch on very briefly is just a sequence or an alternative process. In approaching this submission, I don't mean to take the wind out of my own sails or to undercut any of the submissions that I have made today in support of my application. The purpose for these submissions is really to, in one sense, highlight the complexities of what's before this court, but also to try to assist the court to work out a way forward if I'm not successful on my application. Because if the matters or claims aren't summarily dismissed, it will have to be made clear about which claims stay, whether they are struck out or need to be repleaded or redrafted, whether evidence either from the plaintiffs or the defendants are required. And then the other issue, of course, is if that doesn't occur, if the plaintiffs don't comply in either moving this matter along towards conclusion or, if recorded, preparing and filing new drafts to the originating motion or new drafts to the amended summons, whether the court should be ordering, in my words, some form of sunset order, that if those matters are not complied with, the proceeding is automatically.
I think one way or another, it's likely that we're going to convene again when I've expressed some views about what orders should be made, and you can raise issues like that.
Very well, Your Honor.
If appropriate, depending on what I decide.
Yes, the final point then to make is just in relation to my summons. There are a variety of claims that are being put, but of course, it's not just summary dismissal and a strikeout or a matter of the documents being set aside whether the proceeding should be stayed. And that's, of course, stayed in a temporary sense. Because one of the key issues that I've raised is what claims are to progress to trial. I say, of course, none of them. But if there are some that go to trial, how is it that any or all of the defendants are to meet those claims and prepare for a trial? And until that occurs, the court should, in a sense, stay the proceedings until the matter is ready for trial. And that would, in my submission, prevent a variety of things occurring in further applications and further subpoenas and further discovery.
So go back a step, I have lost the thread of what you are saying now.
Yes, the first step, really, should be if there is a claim or claims that can progress the trial.
Have you heard from the defendants?
Yes.
I look at this and decide what I think about the current state of play.
Yes.
All right.
Then.
And assuming, for the sake of argument, that some, or all of it goes ahead.
Yes.
Yes.
Then the form in which that is going ahead, and if there is an issue with the form of some or all of those claims, that should be dealt with first. The defendant should not have to be dealing with not knowing the case that is against him while trying to deal with possible applications for discovery or possible subpoenas that might be being concurrently raised.
When you say, and not knowing the case against you, do you mean not being aware of the material facts, so to speak, that the plaintiffs are going to prove to make good their claim?
That is so. Both the material facts, but also.
Because, sorry to interrupt.
Yes.
Ultimately, the plaintiffs, if they have their way, will be asking me to draw inferences of bad faith or improper conduct, which inferences will have to be drawn from certain established facts.
Yes, I accept that.
So I am trying to tease out what you are saying in terms of you being prepared. What you are saying is your clients would have to know somehow or other that the facts that the plaintiffs are seeking to, not the conclusions.
Yes.
But that the facts that the plaintiffs will try to prove from which it will be said an inference of misconduct should be drawn.
That's so. And not just that so, but also the other point that I was making is also in terms of the aggregation. That is, we cannot progress to a trial merely knowing that all of the defendants are said to have done X or Y. Not only what are the material facts, but what are the facts, how are they referable to either each or all defendants, and even the conclusions. How are the conclusions sought to be proved referable to each or all defendants?
Yes, well, there is being in a position to deal with the evidentiary allegations, and then being in a position to deal with the arguments that flow from them.
Indeed, but the problem, as I have sought to identify in the originating motion and summons, is for many, if not the vast majority of the claims, is it is wholly unclear about what is being put against one defendant. It seems at some point that all of these allegations are being put against all of the defendants, and that is very unfair where someone like Mr. Nayland's appointment ceased a very long time ago. So it is not just a question of, apologies, Your Honour. It is not just a question of the material facts, which is very important, but it is also a question of, well, if there are some or one or many claims that can go to trial, the form of those claims need to be disaggregated against each of the defendants.
Okay, well.
And this is where, and I just pause to note, and I know I have already made this submission, Your Honour, but I just pause to note that the language that I am using is really language that is rising in negligent claims, in tort. And this is the problem with this proceeding. I mean there is.
Well, yes.
Yes, Your Honour.
Yes, no, look, there is a flavour of judicial review, a flavour of tort, a flavour of, yes, misconduct.
Yes, and even a flavour, in some senses, of a criminal proceeding.
Yes.
And that, I think, needs to be made clear. Because one of the other issues that of course will arise, and I just want to be really clear that I am not sure what will arise, but I also don't want to be in a position, and client does not want to be in a position, where we are having to, essentially, have, my words, like a boomerang or a rebound application where Your Honour has made a decision, sought or directed the plaintiffs to replead or redraft certain documents, they do so and then we are in a position again where I am here, or someone is here saying these are still criminal allegations that are being put, or criminal findings that are being sought, or the conduct is still aggregated or the material facts have not been made clear which is sought to be proved. And I was not being, I hope, too tentative in raising this issue of sunset orders, but at some point, if I am not successful wholly in relation to this claim, there will need to be, and I have said this before, Your Honour, but a line drawn in the sense of we are 1 year down the track and it is still unclear what is being put against the defendants.
Yes, unclear, you would say, to the extent necessary to have a properly run trial?
Yes.
It is clear that there is alleged misconduct in the.
Clearly.
Yes.
And I accept that. It is clear that they are saying people have acted maliciously, that there has been misconduct. That is, when I use that sense of unclear or unintelligible, the language in the writing used is very clear and very intelligible in the sense that it makes sense, but is unclear or unintelligible in the sense of, as I have already said, what are those material facts? How do they get to this conclusion? Who is that put against? And all of those questions are still unanswered 2 years later.
Yes, all right.
Your Honour, the court pleases.
That is what you want to say?
Yes.
All right. What I was thinking of doing is adjourning the application until Friday next week, Friday the 6th of September. Is that a day that you could accommodate, Mr. McAuliffe?
Unfortunately, I just will be before your brother Judge Beale in another matter on Friday, but I will have a leader in that matter, so it just depends on what time Your Honour will.
Well, what I was thinking of doing was having that as a day on which by that time the plaintiffs will have had an opportunity to absorb what has been said today from the transcript, to the extent that they have not joined the hearing, and I was thinking I would give them a day to make submissions in response.
If it is, I might have to take instructions. I certainly would not be available for that whole day. If no submissions are being sought on that day in reply, it might be.
There may have to be some reply.